Collection Service Board meeting to order, May the 13th, 2015. Ms. Whaley, would you give us the roll call, please?
Yes. Bart Howard,
Present.
Elizabeth Trinkler,
Present.
Steve Harb,
Present.
Elizabeth Dixon is absent, Chip Hellman is absent. You have a quorum, sir. I'll read the notice of meeting. This meeting's date, time, and location have been noticed on the Tennessee Collection Service Board's website, included as part of this year's meeting calendar since August 4th, 2014. Additionally, the agenda for this month's meeting has been posted on the Collection Service Board's website since May 7th, 2015. This meeting was also noticed on tn.gov's public meeting calendar.
I'll get copies of the minutes in the email. Any questions?
We could adopt the agenda
Oh,
for
sorry.
today's meeting.
Entertain a motion to adopt the agenda.
So moved.
Second.
Moved and seconded, all in favor?
Aye.
Aye. Minutes. Has everyone had an opportunity to review the minutes? Motion to accept the minutes.
I'll make a motion to accept the minutes.
Favor say aye.
Aye.
Okay. Legal report.
Item number 1, are you guys ready? Are you there and ready? Oh, I don't think Mr. Harb is just yet. Take your time, it's okay. Okay. Yeah, I guess, I don't know how you guys want to do it. Every board does it differently. Is it better for you guys if we just do it as thing, or do you want to take each item and then vote on them individually? What works best for you guys?
What we've done in the past, which is okay with me, if we review them all and then have questions, we'll go out after that, and then we approve the whole.
Yeah, it might be less confusing
I
that
can't
way.
remember between them.
Yeah.
I'm slow.
I probably also won't remember, so. Okay, item 1, 2014-032281. This complaint alleges that respondent, a third-party collection agency, failed to comply with state and federal law pertaining to the credit and collection industry. The complaint involves a student loan that was placed in a Chapter 13 bankruptcy proceeding in 2006, which complainant alleges was paid off early in 2009. Complainant stated he was aware that the loan could not be discharged and requested a full payoff of the Chapter 13 and the student loan. Complainant alleged he made the payoff and was surprised to get a payment notice 6 months later. Complainant stated he then contacted his bankruptcy attorney, who stated he had done everything required in the Chapter 13 matter. Complainant alleged that in October 2013 he received a garnishment notice from a state guarantee agency directing that the state of Tennessee garnish 15% of complainant's wages. Complainant stated that according to TCA 6220-127B3, he should have been in the county in which complainant resides at the commencement of the action regarding this outstanding debt, and this was not done. Complainant stated he was not given an opportunity in a court of law to explain why this loan still had an outstanding balance. Complainant also stated that according to TCA 6220-127C, an attorney licensed in Tennessee should have commenced litigation, and this also was not done. Complainant participated in an administrative hearing to determine if he could pay less per month. Garnishment order was upheld. Respondent sent a response to the complaint stating that complainant's guarantee agency account was placed with the respondent for collections in May of 2013. Respondent's records indicate that they have had several conversations with complainant in regards to the rehabilitation program options available for the account. Respondent stated that on October 30th, 2013, it received a letter of dispute from complainant in regards to his account. On November 4th, 2013, it received complainant's first garnishment payment in the amount of $194.59. On November 5th, 2013, it received a request from complainant to obtain copies of all records relating to a student loan. This information was sent to him on November 8th. On November 22nd, 2013, complainant contacted respondent confirming receipt of the information and advising that he was having an attorney review the documents. On April 3rd, 2014, complainant contacted respondent requesting a settlement in the amount of $16,495. On April 14th, 2014, complainant contacted respondent requesting to decrease the settlement to $7,400. The offer was not accepted as it was not within the guidelines that respondent can accept. On June 16, 2014, respondent received a request for an untimely hearing due to hardship, which was filed with respondent and scheduled for September 9, 2014. On September 30, 2014, the final hearing decision was received upholding the 15% garnishment. Respondent stated that it still would like to offer assistance in placing complainant and his account in a rehabilitation program. Recommendation in this matter is to dismiss. Complainant did not provide sufficient proof of a violation on the part of respondent. Okay, if there's no questions, we'll keep going, but if there are. Okay.
Fine.
Item 2, 2014032291. I'm sorry. This complaint alleges respondent has failed to verify the subject third-party debt. The complaint alleges that respondent has ignored complainant's request under the Fair Debt Collection Practices Act to provide verification of an alleged debt of $676.22. The debt appears to be owed to a medical provider. The allegation is a violation of TCA 6220-115B5 and the Fair Debt Collection Practices Act, which states in pertinent part as follows. And I just provided that section of the Fair Debt Collection Practices Act that they were alleging the violation. I won't read that part out loud because I'm sure you guys are familiar with it. Respondent failed to file a response with this office. Office of Legal Counsel attempted to contact the complainant in the matter. She did not answer and her voicemail was not set up, so there was no way to leave a message. It appears that notification to the debt collector has to be in writing, but it states that collection of the debt must cease if it is disputed until information is provided. There is no proof in the file provided by complainant that respondent continued to attempt to collect. Complainant just states that they did not provide verification. The recommendation is, counsel recommends the authorization of a civil penalty in the amount of $500 for failure to respond to the complaint, which is a violation of TCA 6220-115A3 and TCA 6220-115B4.
Had a problem with this complaint, this person before, this agency before?
Not to my knowledge. This isn't like a repeat offender or anything like this. Okay, item 3, 2015-00451. This complaint alleges that respondent is trying to collect a debt that is not the complainant's. Complainant states she has not been in the state alleged by respondent and has never owned the automobile that is the subject of the debt. Respondent filed a response stating that they have not violated any collection laws at the state or federal level and that they noted the account as a dispute and closed the account accordingly. Respondent stated that the notice that complainant provided is dated April 23, 2014. The account was closed and returned on or about July 16, 2014. Respondent stated it did not report the account to the credit bureaus and notified the client of complainant's concerns. Respondent provided legal counsel with documentation showing that complainant's account was closed on January 13th. There is insufficient evidence to prove a violation on the part of respondent, thus counsel recommends that this matter be dismissed. Item 4, 2015-00148, and that should say 1 also. There should be a 1. I don't know why I missed that. Complaint alleges respondent is in violation of professional standards that require them to communicate directly with their attorney regarding an alleged debt rather than with complainant. The complaint alleges that complainant was first contacted by respondent on August 27, 2014 via mail concerning their claim on behalf of a medical provider. Complainant stated that she had fully and finally resolved any and all issues with such medical provider and asked her attorney to contact respondent. Complainant's attorney sent written correspondence to respondent on September 4, 2014. Instead of acknowledging that correspondent, respondent ignored the letter and continued to contact complainant via written correspondence with a second notice letter dated September 26, 2014. Complainant's counsel responded on complainant's behalf by letter dated October 3, 2014, again requesting that all communications be directed to counsel and not to contact complainant directly. In response to counsel's October 3rd letter, respondent sent a detailed summary bearing no letterhead or other indication of the author directly to complainant. In addition, counsel states the alleged debt that respondent is attempting to recover is one that was fully satisfied by complainant over 2.5 years ago. Respondent failed to file a response to the complaint. Legal counsel contacted complainant's attorney on April 29, 2015. Did not return my call. Recommendation is counsel recommends the authorization of a civil penalty in the amount of $1,000 to be satisfied within 30 days of execution of the order for violation of TCA 6220-115B5. Statute states in pertinent part, the board may suspend, revoke, or refuse to renew any license held under this chapter for any of the following causes. Section 5, failing to comply with any applicable state or federal law or regulation pertaining to the credit and collection industry. Such terms to be settled by consent order or formal hearing. And in addition to that civil penalty, part of it is that respondent failed to respond to the complaint, which is a violation of TCA 6220-115A3. Okay.
Letters did the collection agency send to the debtor after they were advised not to?
It looks like they sent 2 separate letters after the first letter that the attorney sent, saying not to contact the complainant.
Respond to the complaint.
Correct.
My own personal opinion, it ought to be $3,000 for the 2 letters that were in violation and the failure to respond.
Certainly be 3,000 if you think that's, because we can do up to 1,000 for each violation that you find.
Flag this agency, there's something wrong with them.
Probably at the
Probably at the
end.
end, okay.
I'm just going to jot it down really quick for myself. So,
The name does not jump out at me, but it certainly
It'd be nice to know
Prior
in the
discipline.
future
right.
how many times somebody has
if they're
had a level of complaint.
We can start including the complaint history on the legal report and any disciplinary actions that they might have had from this point. Okay. Okay.
Very abbreviated,
Yep.
repeat offender, first time, that makes a
Okay.
difference.
All right. We can do that. Item 5, 2015002841. This complaint was filed alleging respondent is representing itself as an attorney. Complainant alleges that when she asked about whether respondent firm were attorneys, respondent stated that the firm was a collection agency, but they work hand in hand with attorneys. Complainant alleges that respondent claims to have an agreement to start collecting the debt when in reality there is no conversation or agreement between the parties. Complainant alleges that this is deceptive practice on the part of respondent. The individual who wrote the letter to complainant regarding the debt was a senior account executive for a respondent agency in the state of Tennessee. Respondent sent a response to the complaint stating they were a transportation collection agency with their office located in another state. Respondent also stated they retain attorneys in Tennessee and states across the country to assist them in collection efforts. Respondent stated it also employs non-attorney collectors and salespeople. The recommendation is the authorization of a civil penalty in the amount of $1,000 to be satisfied within 30 days of execution of the consent order for unlicensed conduct. Such consent orders to contain cease and desist language applicable to the respondent and any agents working on its behalf, prohibiting the respondent and its agents from collecting debts in Tennessee until and unless appropriate licensure is obtained, such terms to be settled by consent order or formal hearing.
So this is not a first-party debt collection, this is someone who is hired to collect the debt by the first,
Correct.
do we, Did it say medical debt? Transportation debt. But did it originate from transportation debt? Do we know?
That I'm not aware of.
How do we know that they aren't collecting
That's what I'm
in
that's what I'm
Tennessee?
saying.
I mean, if this one has come to the surface, I think calls and collection efforts have they made into the state? Not just for the one they got caught doing, if they're on a continuing.
I'm trying to determine if we would be able to get that information.
The authority, since they're unlicensed, we don't control them.
I'm not sure how we would even get our hands on that.
Practice of yours, how many letters have you sent into the state? Yeah, and,
They're not wanting to pick up today. We have to be close.
okay.
I'm sorry.
No, I appreciate it. So, I think we just need to investigate a little bit exactly what they're doing.
Likewise, the client, whomever they're working for, has an obligation too. We had, several years ago, we had a cable company had employed an illegal debt collector, and that cable company was responsible for part of the issues too. So this could be I know we could sue them and request and have discovery and make them
Right.
bring in information, but we'd have to start a lawsuit first, I think.
Instead of asking them
It's gonna be
who
hard.
else, how many others they've called, can we ask them who they did this on behalf of as a part of the settlement? They need to disclose who their client is, and then send a cease and desist to the client. Can we do that?
Certainly ask whatever questions we want to ask. It's just a matter of will we get responses. But I mean,
Well, the other thing, we can ask the complainant who they got service from that they were sued on, who they owed the debt to that they were chased after about.
That's likely in the debtor's complaint.
Yeah.
It's just not listed here.
okay, I have an idea. Maybe I think this might be helpful. We might can just keep going through the legal report. She can go upstairs and get the information that we have in the file. There may be an advertisement in there. I can't remember exactly which one this is. And we may be able to answer your questions without having to hold on to it.
I'd like to know whose debt it is, because we
Yeah.
should contact them.
Maybe if we could just defer this to the end of the report, or just maybe a little bit further down in the business, we might be able to get you an answer.
Good idea.
Okay. I just don't want to put something off if it's there and it just wasn't something that I realized was important and I didn't put it in there, which is highly likely. I'm getting the hang of it slowly. Okay, so we'll move on to item 6 while she's getting that information for us. 2015004381. This complaint was filed alleging that respondent ran a transaction of $100 that was for someone else's account rather than complainant's. Complainant alleges respondent promised to overnight the $100 to complainant on February 4th, 2015, but complainant has not received the money to date. Additionally, the complaint alleged that respondent is not licensed in Tennessee. Respondent filed a response to the complaint stating that due to an error when they received the second account on the complainant, their system linked both of complainant's accounts and they were worked. Respondent also stated complainant was overcharged $100 and that has been refunded and the check has been cashed by complainant. Respondent stated that it received one account for complainant on August 26, 2014, did not work this account due to not being licensed. Respondent stated it received another account for her on December 1st, 2014, and the system linked the accounts together and somehow permitted the accounts to be worked. Respondent stated it has remedied the problem and no other accounts were affected. Respondent further stated that complainant settled her 2 accounts, but inadvertently an error was made and she was charged the additional $100. Respondent stated the reimbursement check was sent to complainant and cashed on February 13th, 2015. Respondent also stated it sent complainant the settlement letters she requested. Office of Legal Counsel contacted respondent on May 7th, 2015 to inquire as to whether it could send us documentation showing the check that was sent to complainant. On March 8th, 2015, respondent sent legal counsel documentation showing that the reimbursement check was sent to complainant on or about February 4th, 2015 and cashed on February 12th, 2015. Council recommends the authorization of a civil penalty in the amount of $250 to be satisfied within 30 days of execution of the consent order for unlicensed conduct. Such consent order is to contain cease and desist language applicable to the respondent and any agents working on its behalf, prohibiting the respondent and its agents from collecting debts in Tennessee until and unless appropriate licensure is obtained. Such terms are to be settled by consent order or formal hearing. And my logic in that situation, just in case you're wondering, because it's kind of a strange number, the respondent is not licensed. As you can see, it says unapproved applicant as of 12/10/2014. So they don't have a license. So to me, unlicensed activities still took place because this person's account was worked. However, they did try to remedy the situation by reimbursing her the $100 because they knew they weren't licensed. So
They also collected the money. They finished collecting it. It says that she paid up the whole bill, but there's a bona fide error somewhere out there, and it sounds like they made a bona fide error with the linking of the second one, fessed up to it, corrected it.
right, yeah.
I mean, it's not like they didn't know they shouldn't be collecting in the state.
Yeah, and they did respond.
And they did respond, they did send her the money, they
To
did
the-
what they said, and in a way, they kind of need to be slapped for the bona fide error or the error, but it wasn't a bad faith error.
Right, I agree. I'm with you
So,
100%.
If you hit them with something, $100 is not gonna hurt them just to smack them, but it ought to be de minimis. I know $250 is theoretically that way, but,
Right, so I think what you're saying is
oh,
250 might be, like you don't even want the 250. We can do a letter of caution, just saying, or a letter of instruction saying, we realize this happened, you had clearly attempted to remedy the situation.
they seemed in earnest to respond. They
Just be
got-
careful in
They got
the
you the
future.
information timely.
Right, I agree.
They knew it shouldn't be linked. They fessed up to that. I mean, stuff happens. I mean,
Do we know why they weren't approved as an agency? Apparently they made application.
They haven't completed the process.
Okay, so they're still working on it.
So,
Alright.
And we allow the 6 months.
and as she suggested, it might be a good idea if we do a letter of instruction to kind of also remind them that their application is still pending and they might want to try to complete that process. And then this
Idea.
might be easier for them if they could just get to that point.
Okay,
I'd rather just smack them. How do you guys feel about
I
that?
think that's fine.
I'm
A
fine.
letter of warning, and
Letter of warning and instruction.
Yeah, we can call it warning or instruction. Instruction seems, some people like instruction because it doesn't seem, I guess, as severe, but this is not really a severe thing anyway, so.
A warning's better than an actual fine. I mean, I know they made a mistake, but it doesn't sound like they did it in bad faith.
Language in it to tell them to move the process along on their application.
another question that I have is that apparently she had an account that was, when the second account was listed, it was added to the account. Or were they collecting the first account?
No, they said they weren't in the notes.
Right.
They were not
Right.
attempting to collect it, okay.
It linked, it had already been set aside from the way the notes read.
Okay.
I mean, that's what, it seemed like you said, that they had
Right,
set it
and
aside.
that's what I got from the information in the file.
Should be a warning, because if they don't get their license done and it happens again, they may not get a license.
Right, and
So they need to know to get jolly on the spot or stay out of the state.
maybe not. Maybe I'm not in so many words, right?
Say that.
You understood.
Although I like that.
I mean,
yeah, that was actually pretty good.
Put it
I
in
would like
quotes.
to use that if possible.
Put it in quotes.
Yeah, I will. I'll give you all the credit on that
No,
one.
I'll stay anonymous.
Yeah, I also don't like too much credit myself. Okay, item 7, 2015-004801. This complaint was filed alleging that respondent placed a debt on complainant's credit report without notifying complainant. Complainant alleged that it made several attempts to make payment arrangements with the original creditors and was unaware that the creditors sent the balance to respondent. Complainant alleged that respondent failed to comply with the Fair Debt Collection Practices Act in advance of reporting to the credit agencies, has impacted his credit and his credit score. Complainant alleged the debt was paid in full on February 4th, 2015. Respondent stated after respondent contacted complainant, it removed the debt from the credit report due to complainant not receiving the first letter because of an incorrect address. Respondent stated the complaint was resolved on February 2nd, 2015. Respondent stated that it received both the complainant's accounts on December 4th, 2014 for the purpose of collection. A day later, respondent attempted to send a letter to complainant, but the address supplied by the original creditor was inaccurate. On January 25th, 2015, respondent sent the accounts to the credit reporting agencies to be reported as collection items. On January 30th, 2015, respondent obtained a new mailing address for complainant and mailed a letter which contained all required language to the new address. On January 31st, 2015, respondent attempted to contact complainant by phone and reached his voicemail. On February 4th, 2015, complainant contacted respondent's office complaining of having tried to set up payment arrangements with other companies prior to respondent, but was unable to do so, and that the account was on his credit report. Respondent stated that even though it is not required to notify a customer prior to placing a credit item on a credit report, it decided to remove the item from the credit file since complainant did not receive the first attempted letter because of the bad address. On that same day, respondent placed a request with the credit reporting agencies to remove the credit item. Respondent stated that in complainant's complaint, he claims the accounts were placed on his credit report on December 4th, 2014. Respondent states they were actually sent to the reporting agencies on January 25th, 2015. Respondent stated its company acted in full compliance with the law while it attempted to collect the debt that complainant owed, as well as took extra steps to satisfy complainant by removing the accounts from his report. The recommendation is to dismiss. Item 8, 2014-028551. This matter is a representation from the March 2015 Commission meeting, during which the Commission requested that the matter be deferred to the May meeting in order to obtain further information as to the respondent. Specifically, the Commission wanted to know whether respondent was an employee of the check cashing company, how respondent was paid, whether respondent's an independent contractor, and whether respondent's collecting debts for other creditors, and whether respondent collects debts in the name of the company. The facts were presented at the March 2015 meeting as follows. So what you see there in the italics, that's what was presented to you in March, and then you guys voted to defer it for more information. I don't know if you need a second to look over that before we get into the new information that I found.
Give us just a moment to read
Okay.
that.
This is a tough one.
Yeah, just let me know when you're ready for the new stuff.
Okay.
What?
Yeah.
I know, it is.
I
and
just
that's-
read the new stuff,
I think that's
yeah.
why you guys probably deferred it the last time. It was a little tricky, but
Oh,
hopefully.
the answer makes it even tougher.
Oh,
Still
the
didn't
new-
answer the question is she collected in the name of check cashing company?
Yeah, she was.
She was
She-
very
she- yeah,
much
She
doing
was
that.
collecting the check
Yeah.
cashing company, and she wasn't an employee, but she got a commission. She wasn't contract labor. She did it kind of for nothing, but she got a commission when she collected something. And
Right.
she's a friend of the owner. She worked for the company.
So too.
The
Yeah.
owner, when I spoke with the owner, she stated that the respondent was a friend who had a background in this type thing. And so on several random occasions, she didn't really know how many, more than one, that she had just come in to help her collect these debts. But it was in the name of the check cashing company. But the owner stated that she did not pay this person. She
But
was not.
then she said she
paid her-
gave her commission
Right,
when she
commission,
collected
but
something.
that she wasn't
She
an
never-
employee.
But
of the
she
company.
never actually received commission because she never.
Correct. Did you catch that? She never actually received commission because she wasn't successful in collecting.
That was her purpose, is to collect it for a
Right.
commission.
When she did collect something, she got a commission, didn't she?
That was the understanding that the owner gave us. If she did collect the debt, she would receive a commission.
Know if she collected for any other check cashing companies, or was this the only one?
Why would that matter?
Well, I believe,
Is it the two?
Only that
I think
if that's
that
what,
it was
if
only
that's
for
what
this
she's
one.
doing, you know.
yeah, I believe the owner said during the phone conversation that she did not have knowledge of the respondent collecting for anybody else. It was just this particular check cashing company.
Did she request the money to be sent to her individually, or just to pay the check cashing company? Do we know that?
Probably the check cashing company would be my
Yeah.
guess. She
If she
just
was-
probably came in and,
She was doing it in the name of the check cashing company.
Yeah.
Where else would it go? She was just helping out a buddy.
yeah.
It sounds like first-party debt. She wasn't holding herself out to be a third-party collector.
Yeah, that's what's.
I agree
She
that,
needs to cease and desist anyway, but,
Right.
or declare herself to be working for the check cashing company under whatever payment terms. How she gets paid is immaterial to us, or whether she gets paid, but, how did we get notice of this?
Or just a complaint was filed. Yeah, a complaint was filed, and they alleged that the respondent was violating the Fair Debt Collection Practices Act by contacting complainant's father-in-law regarding a debt that complainant owed to the check cashing company. Alleged that the respondent told her father-in-law that unless they called back, she was issuing an arrest warrant.
Well, she's a third party, so they're alleging a violation of third party.
Yeah. But if she wasn't a third party, if she was doing it in the name of the check cashing company,
Right.
actually do that.
Well, I mean, no, but talking to her father-in-law, she disclosed. Is she saying that she disclosed?
But that's a first-party disclosure.
Yeah, that's what I mean, yeah.
yeah, we don't regulate that.
No, we don't regulate, I
Yeah.
mean, no.
A little
I
tricky.
think, yeah, well, yeah, I think a stern letter of warning that when she called, and we don't know how the conversation went. We don't know if she actually used her name for check cashing I'm Bart Howard with the check cashing company so-and-so, and I'm calling to collect the debt. If she did that, then I think she's perfectly fine.
Yeah, if you want to do a letter of warning, just if you could just give me like one or two things that you think would be the most important standout things to say, like what stands out in your mind as the biggest thing here.
Biggest thing is that when she does this, she needs to do it in the name of the company.
Okay.
She needs to call and tell them that she's collecting for XYZ company, and
Her personal background doesn't matter.
her personal background doesn't matter, and make sure that that all the money is sent directly to the check cashing company, and she doesn't receive any funds.
And I think she addressed something about threatening language, that she doesn't need to be threatening actions that doesn't intend to take or whatever.
The
that
check cashing
might-
can't
company
do it.
can issue a arrest warrant for a bad check.
They can?
So they can. So if she was gonna threaten that, and it would make it more like she's doing it on behalf of the check cashing company, who has the authority to do that.
How can a check cashing company issue a warning, or I mean,
Bad check.
a promissory note? They didn't take it as a bad check, they
That's
took
true.
it as I'll pay you later.
Knowledge.
Promise to pay. Yeah,
We don't know that.
Yeah.
If they just cashed a check, it check to cash.
Okay.
If it's
Not a
check to cash,
It's not
you're
a
right.
loan, it's not a loan. if
They
it-
just,
if
they just
can't-
cash the check.
Then it would be a criminal.
Yeah, yeah, it could be. If they cash the check and it bounced, then they can go after them. But if it's a check to cash, which is a promissory, that's different. We don't know all those facts, but check cashing company is not a check to cash company. Those are different.
Okay, I'm taking down areas for the letter of warning. So, if you got more questions on that one, we can go back to, I think it was item 4. Was item 4? Item 5. I'm sorry.
Yeah, transportation company.
Yeah.
This item, this was originally an email that was sent out, and it appears to be a solicitation email for collection services. Hire us to do your collecting, is what it is. The email, the location is out of Memphis, which is not location. The company itself out of Mississippi is licensed, but not the Memphis, which is where the solicitation appears to be.
Out of Memphis, but they are licensed in. No, it's okay.
Does the salesperson that works for the Mississippi company live in Memphis?
I believe they have they have a office that is in Memphis. The parent company is in Olive Branch, Mississippi.
They have to have a license to solicit for business.
So yes. So you have the one office that is licensed, you have a second office where this email signature line states that they're coming out of Memphis as opposed to Olive Branch.
Olive Branch office licensed in Tennessee,
The Olive Branch office is licensed.
so they failed to disclose a branch office.
I think they have to have a license of their own, don't they?
Yeah, it would be a separate.
Yeah.
Agency would have two. Mississippi would have one. The Memphis would also have one, an agency license. Mr. Howard?
Or you can't solicit to do business or solicit for collection business without a license.
They would have to have a separate license.
So they definitely did
Each
that.
location has a separent license
Each location has a separate license
of the same company.
of the same company.
Okay.
Don't they, Elizabeth? There used to be a branch
I know we
office.
went round and round on this. I thought it was a branch office thing, but,
The branch is for Tennessee-based companies, is how it's previously interpreted, is my understanding. But you all have way more history in the business and on the board than I do.
I think some time ago, we stopped recognizing branches. and require them to, if they're gonna solicit out of there or collect out of there, they have to meet the same requirements as they do if they were actually a company,
But if
particularly if
it's-
they're taking money in trust accounts and so forth.
Even if it's the same, there's only one company and it has an office location, but the office location does everything through the trust account of the main company. Satisfy our requirements I don't know enough about branch office requirements.
I think the branch office issue was that if you're located in Tennessee and you have a branch office in California, then that branch office in California does not have to have the licensing requirements as Tennessee. And it goes back to when we used to have a collection manager license, and my managers used to be.
That would make a difference, yeah.
That did make a difference in then, but I think since then, we've not, as long as the company is in Tennessee and licensed in Tennessee, if he has a branch office elsewhere, we don't require that branch office elsewhere to have a license. Now, that may just be because we like it
But
that
now it's
way.
reversed. The company's in Mississippi and has a branch office in Tennessee,
Well-
but it has a license out of Mississippi for Tennessee.
No, I think he needs, if he's in Tennessee and operating in Tennessee, he has to have a license. He's soliciting for business. If he indicates that his office is in Tennessee, then he has to have a collection license.
Well, he'd have to have a solicitor's license
Yeah.
in addition to the collector's license. 'Cause
Well, you license the location, the agency, and then you tell us how many solicitors you have. And they get it's a little card that is tied back to that agency.
I think if I was this company, I think I would do away with the Memphis address, unless they're operating a big business there and they have collectors and salespeople and what have you. And this fellow who's, I imagine or assume that he is an employee of the Mississippi agency and just doing sales work for them. But we don't know that. If he's
He's attempting to collect a debt.
He's soliciting business. He's not collecting a debt. He contacted a office to offer the services. There was a PowerPoint looking.
Know if he has a solicitor card, or if the company has at least the licensee, do they have more than one solicitor card?
I would have to go back to the office to look to see how many solicitor cards the company. I'd be more than happy to go find out. The solicitor cards are not issued to individuals.
Oh, but
They're
if a
just issued to the,
company.
Mhm.
But if they only have one, we don't know how many solicitors they have. Sounds like this is not the main solicitor. But we don't know that,
yes, with a license, you get one solicitor card,
unless you ask for more.
and then you request additional.
They're like $25 each or something.
Yes, sir.
Yeah.
30 years of business, I don't think I ever carried a solicitor's card with me.
But you had one in the office.
Somewhere, I suppose.
You did. I know where mine is. It's sitting next to the license.
You didn't carry yours, Bart?
When it comes, it's on the
confessions.
same card, Bart.
Statute of
It's a little-
limitations is already
You
run.
open it up, there's a little card that you punch out,
Yeah.
and you fold it and you
Yeah.
put it with the
I've
license.
seen one.
Yeah.
I never went anywhere without mine.
I can check with the office if you would like to.
I don't think the solicitor's card issue is going to change my mind one way or the other. I have a feeling that this fellow in Memphis is just an employee of the agency listing business, and he lives in Memphis, and Olive Branch is just a, a rock throw from
Right.
Memphis anyway. So he just happens to live there, and it's the listing business.
Right, and it does list him as the senior account executive for the respondent agency,
There you
so
go.
that's true.
There you go.
Yeah.
I think maybe just a letter of warning that he not use a Memphis address as his business, and that if that's what he wants to do, then he'll have to have a Tennessee Collection
Separate
Service license. Yeah.
Right.
And I think
And
we
maybe make sure he does have a solicitor card, just so
Yeah,
that
yeah.
you,
Okay.
you do need to have
And-
one if you don't.
And perhaps, I don't know if it's okay to send a copy of the letter or send a letter also to the Mississippi agency reminding them.
Yeah, we can do that. There's nothing wrong with that.
Is that okay with everybody?
Yeah.
Yeah, that's good.
They're licensed, so they should get correspondence from us.
Right,
Yeah.
yeah.
They,
At the end of the legal report?
I make a motion that we accept the legal report with the changes so noted.
second.
And seconded, all in favor, say aye.
Aye.
Aye. Okay. Complaint comparison report?
Yes, sir. Okay. Currently, there are 56 open complaints for the Collection Service Board, and
That's
I-
fantastic, y'all. Way to go.
yes, well, this is actually up from the last meeting. We've had several agencies, we keep up with this, whose bonds have expired. So when we reach out to them and they don't reply, we open a complaint against them. Typically, they will comply and get us their new bond, because the bond runs for a calendar year, which is usually not typically concurrent with their 2-year licensing cycle. Regular occurrence, so just so if, the performance measure is currently at 93.33%, so that's well ahead of the division's expected performance, quite well.
Good for you.
There are no questions. We'll move on to tab 4, which is simply your monthly budget report. You have the revenues and expenses for the board.
How bad is the manager's license hurting us financially? Or,
I don't believe it is. We've had a number of agencies currently, and this was part of my renewal report. There, over the course of the year, I believe it's 98 new agencies have applied.
net new?
Some of that probably would include some reapplies if someone goes past the 60-day renewal period. So there'd be a few sprinkled in there. Yes, we did see an increase in agencies, so. Other questions about the budget? If not, I'll move on to the applications I have for you.
We're ready to go.
Okay. On tab 5, this is a renewal application. And draw your attention, the first couple of pages are an email exchange, and apparently at some point back in time, the board reviewed Colorado does not require a CPA license, and the board said that it would accept their financials without.
On the board?
Used to.
I missed that meeting.
This is some time ago. These emails are dated 2011. So I'm representing this because it has been some time, and we've recently revised the renewal application, and I wanted to bring this to your attention and potentially provide the company with some guidance, or their financial information is located on page 12 on your iPads.
Remember when, the meeting when we said we don't need a CPA to sign?
Oh, I remember, one thing I remember about that was something about Canada. Remember there was like a different, I remember a Canadian agency or something, there was a different way that they designated accountants or something, but I don't
Chartered or
remember.
something. They're chartered, they're not CPAs, but
Right,
they're
but
chartered.
I don't remember
They have a-
anything about Colorado, and I can't imagine, they're so tough on their collection licensing.
Yeah.
It makes no sense to me that they wouldn't. Is
Well-
it just a different way they designate them, or?
I don't know. At one time, we authorized, what do they call them? Not, is it licensed public accountant or PC?
Yeah, it was something like that. Mm-hmm.
PCs, oh my gosh, I'm sorry.
We
I
don't
didn't
have
read it.
those anymore, so.
I don't recall. I think that would have stood out in my mind because it's just odd to me that one state.
So on our application, we don't require an accountant to sign off on the balance sheet?
On the, yes, your, the law states, prepared by a licensed PA or CP. That's
what I
a.
thought.
PAs are
loose-
now gone.
Yeah.
They are now CPAs. All PAs have been given CPA licenses, several years ago.
We can certainly,
So,
maybe something to add to the legislative cleanup package if that is the case.
A long time ago that PAs, it's probably been maybe 10 years, that PAs.
oh, it's been that
CPAs.
long since we've looked at this application too, or longer.
Well,
What's the question at hand?
the financial information that is provided typically would not meet, based on the guidance that I've been given, wouldn't meet the requirement unless this was signed off by the CPA, which was the direction Mr. Harvey and the board gave previously about this QuickBooks, Peachtree type balance sheet. But they're just saying they don't have a CPA, so they can't give us the compilation, review, or audited.
That only increases my confidence in their numbers. They don't even have a CPA. Who prepares their tax return, for heaven's sakes? I mean, not that that's a rhetorical question. But I think the reason we have that in there is that it's a standard of business expectation that anyone we're going to let hold money in trust for others should at least be doing business at the level where they have appropriate advice on their financial information and can give us a level of protection. Even a compilation report, it is not protection. It is simply taking numbers, putting it in the form of a report with no opinion. But it's a minimum standard that you talk to somebody who went, oh God, I can't put my name on that. It's to me, that's like a threshold of, are we going to let somebody hold money for others out of the state of Tennessee?
I completely understand. Again, that is why I'm presenting it to the board. So if this is no longer the opinion, company does need to provide that, we can send them that, and that it comes from the board.
Well, if the board previously gave a release or authorization not to do it, I mean, I wasn't on the board at the time, so I'm not aware of it. And if the board's already done it, I don't know if we can go back and undo that, if that's appropriate, or I don't know how that stuff works. But if we were going to have a standard to have a report, it should at least be compiled by a CPA. That is our requirement.
Right, and just to touch on what you said, if for some reason you feel like there are issues that you need to go back and readdress, you certainly have the authority to go back and readdress those issues. You don't have to just stick with something just because in the past. Right.
I don't believe that Colorado does not require or does not have a designation CPA.
Well, Colorado has CPAs.
Well, he's saying here that.
That's what he's saying.
He's saying Colorado is not necessary to have a license.
Well, I think they're saying their accountants
Yeah,
are
he's-
not required to be licensed, so they may be trying to use semantics to, yeah.
He
There's a
signed
better
it-
word than
He signed it
semantics.
as comma
Sorry?
PA,
He signed it, comma, PA?
yes. And I think what he's doing is he's going back to our application that's old and outdated to say he's a PA, and in Colorado, PAs aren't required to have a license.
At one time earlier, someone, I think Chip, was reprimanded for using his iPad during the meeting. Can someone Google, does Colorado have PA licenses? Just Google the question and we'll know. I'd be glad to do it, but I don't want to get in trouble.
I will look right now.
Thank you.
Maybe they just have CPA licenses.
They have CPA
Well, they
license.
could
but-
have PAs, and if they have PAs.
I'm just saying.
And this person, I'm not seeing where it said PA, I apologize for that.
Right under his signature, he's written his name, David L.
What page are you on?
Berry, on page 1, the balance sheet of this Paladin company.
Yeah, I see it. Mm-hmm. Yeah, right there.
Rental assistant, what does PA mean in Colorado?
They do, so I think it says they don't require the accountants. Colorado, they're not saying they don't have CPA. I've read this a few more times. Colorado does not require accountants to be licensed. But they do have a CPA designation. I'm on their Board of Accountancy's website.
Don't require accountants to be licensed?
I think
Someone who
I
does
think
bookkeeping.
bookkeeper. I think they're saying this person is the bookkeeper and that they don't require bookkeepers to be licensed, which is true.
Do they have the
this-
designation public accountant, PA, or do they only have the designation CPA? Because in Tennessee, PAs was a license. You were a licensed PA.
I think there are,
They're gone.
that you can't get new ones. I think people who are can remain.
Yeah, or they could say CPA if they want. They got grandfathered.
If they've met the qualifications of CPA.
They got grandfathered.
Oh, really?
So many years. I have a dear friend who I was just teasing her the other day. She's now a CPA and she disdains it because she was a PA for I can't say how many years. She'll get mad at me, but
I don't see anything, I'm just seeing CPA. So I think these were internally prepared. That's what it appears to be. It appears it is their bookkeeper. And so I don't
DL
think,
Bickling and Associates, LLC, no license in Colorado necessary. Signed by DL Bickling, PA, managing member, DL Bickling and Associates, LLC.
Bickling and Associates is a,
Can you
An
look that
accounting
up? Can you
firm, I
Google
suppose.
that?
yeah, I bet
I mean,
that's
I
what
think
it
we
is.
can, I think we can go back on what we said and said,
Absolutely.
there'd been some confusion about this in the past between PAs and CPAs. The board's opinion now is that it needs to be signed by a CPA, which are licensed in Colorado, and you need to get one.
Took the words right out of my mouth, Elizabeth.
BIC.
out of Denver.
Okay.
Accounting, auditing, whoops, wrong thing.
They're not doing auditing. If Bickling does auditing and they sign this PA, we need to complain to their CPA board. That's a misrepresentation.
That was just just the Google search listings.
Guys agree?
I do agree that I think
What
this,
I-
on the instant matter here, we should request them to have a CPA sign off on their, they're playing a game with us. This fellow works for this CPA firm, and he's just signing it as a PA because the CPA maybe didn't want to.
Frankly, if he's doing that to help a friend out or help a client out, signing PA, and he's a CPA, I'm really uncomfortable with their financials.
Oh, I certainly, I will have a conversation with them and explain to them that this appears to be by your bookkeeping, which
We need another level
the
of,
state law requires that the financial statement be prepared by a CPA. It does-
License, say
license,
licensed.
yes.
s-
I
because-
always quote 6220, specifically what it says to them, to make sure they understand that it's not us, it's not the board, it's the law.
Well,
So,
honestly, my concern is Paladin Commercial Group is the person who's applying. That's the company who wants the license, right?
they're wanting to renew.
Okay, then who is DL Bickling and Associates LLC? The guy who said he's the managing member signed as a PA. I mean, he's saying he's a PA by the way he signed this report. If there was a C in front of that PA, we would have accepted it. If it was CPA, David L. Bickling, CPA, managing member of Bickling and Associates, we would have no basis not to accept it.
Well, no, if he were preparing it internally, if he
But-
worked for the company, he doesn't work.
But he signed it as another company. Who is DL Bickling and Associates? I'm looking on the bottom of 12 of 18.
That's what I'm
He's-
saying. It appears they have an outside bookkeeper who does their bookkeeping and prepared this.
Yes. And that's Bickling.
If
That's
you-
Bickling, and so normally we would not accept it unless it's internally prepared. If it were prepared by someone from the signing at the bottom as a CPA.
We can accept it that way.
Right, that's what I'm saying. So we wouldn't accept this from DL Bickling because it's a separate company. It's a,
Yes, well, oh, I see. You're saying because it's an outside firm that's not a CPA firm, that's two strikes. I'm sorry, I didn't understand how you were, yes, that is two strikes.
and I was just clarifying too, that what my guidance from you at prior meeting was still, we can only accept the balance sheet with the signature at the bottom if it is internally prepared.
if we
by the
go,
company.
if we go back to our own, the state of Tennessee.
When they just give us the balance sheet.
And a
Our,
CPA internally signed, a CPA that works for the company signs it. Yeah, and they usually put their license number.
Yes,
There's a
that's
spot.
what we
Yeah. They
asked
have
them to
to.
do. That's
Yeah.
what we asked them to do, is they
There's a
actually,
blank for the license number.
they actually sign it at the bottom.
Yeah.
Complete this form and attach a financial statement prepared and signed by a certified public accountant with their license number and address. That's right on our application.
This is perhaps an unnecessary point, and I apologize for taking your time, but my concern is that whoever this outside guy is agreed to sign as a PA and defines himself as a managing partner of a company with his name on it, and they don't have PA licenses from what you read, or may not have PA licenses in the state.
It does not
That's not the
appear.
kind of person we want to have collecting and holding money in Tennessee, whatever company hired this outside guy. That's why we want CPAs. We want some level of assurance that somebody looked at it some way.
Certainly, I will contact the company.
Okay.
So I guess just a motion to defer pending the receipt. Would the board like to see this again, or do you feel comfortable if I get based on your guidance?
I think if you get this financial statement signed by a CPA with his license number and address, I think we'll be okay.
I typically would expect a compilation review or audited set of financials.
We need a compilation report at a minimum,
Yes, sir.
a report signed by the CPA. If a CPA signs like this and it wasn't internally prepared, that's not a CPA following CPA rules. Yeah.
I'll make that motion.
Motion's been made and seconded. All in favor?
Aye.
Okay.
Let's see, we are, is that the end of the application review?
So there's actually two more
Okay.
that we need to review. So we're on to tab 6. This company, if you'll refer to page 20 and 21 on your, this is a case where the assets do not meet or exceed the liabilities. This is a reapply.
Have an audit report.
Right, 20 and 21. That kind of skips ahead straight to the balance sheet. Six of the financial statement.
Page 22 now? Their page 22?
No, you're looking, oh, it's on the iPad, it's page 20 and 21.
21's a letter?
Yeah, they have 9 million of assets and 10 million of liabilities. Deficit equity of 1.2 million.
Okay.
The iPad pages
Oh,
are
okay,
there.
right there,
Yeah.
but then they go away.
Yeah, you're on 20?
20 and 21, one was asked.
Wow, this is a real anomaly. Their assets don't exceed their liabilities, but they've got an unearned ESOP shares of 2,000,001.
Employee buyout program?
Yeah. They have paid-in capital of 1,000,005 and real deficit equity of 661. So they have 878,000 of equity. Now, I don't know what escrow accounts liability means because I don't know what they do. So if they are a collection agency, which it doesn't look like that's all they do. Asset of escrow cash accounts of 1,000,014. Yeah, they've got the asset and liability offset, so that doesn't matter.
Notes, the escrow is funds held on behalf of others arising from collection of accounts placed with the company in the note.
What do the notes say about the ESOP? $31. Basically, that's a liability for future earnings.
I think it's nothing.
Well, it's something, but the CPA firm that gave the audit report, if they truly had liabilities in excess of assets on an operating basis, they would have a going concern problem. How could they stay in business if they had more liabilities than they had assets? There's no going concern issue in the report. There were prior auditors, but these auditors didn't issue a going concern. But they do show the ESOP. I'd take this as an acceptable exception to the equity problem, because the ESOP liability, which is a future liability, it's money they owe the owner, and if they don't make the money, he doesn't get the money. But they're solvent, or they wouldn't have gotten the report they got.
So if you take out this ESOP, $2.172 million, then they are current.
Well, I'm trying to go back to the right page. I'm sorry, what page?
That's
number?
7.
Page 20.
still got.
Page you on? I'm on page 20.
7 of
They
their.
still got more liabilities,
Yeah.
even if you take that out. They got 9 million.
Allowed to talk among ourselves here?
Yes, as long as you're speaking
Good
in
and
mic.
speak.
Okay,
Speaker, yeah.
sorry. That's the real, I don't know where the asset side of that is, because I didn't see it on ESOP asset,
No.
and
There-
because there's not.
There is not.
Unearned ESOP shares. I don't know enough except to be dangerous about how the ESOP liability is booked, and I haven't seen that before because I haven't dealt with ESOPs before. But that 878 is $1,400,000.
Against, just
And they
take all
had-
this out, go up.
liabilities, and they have that much of positive equity.
Look at their assets, their total, that's what Elizabeth's
only got
looking at.
9.4.
Total assets is 9.4. Total liability is 10.6. I think they're trying to show this ESOP as an asset.
Oh,
because it's a-
long-term debt. Let's look at long-term debt.
6 point,
Yeah.
basically 7.
Yes, but what is long-term debt if it's made up of the ESOP liability? Long-term debt's on page 28. Note payable to the bank of 2,898,000.
That's
That's
real.
the 6 million number.
Yeah. But that line of credit.
That's probably up. All of this has to do with the buyout.
Yeah.
Sorry. No bank is going to loan 2,289,000 on an insolvent company.
Unless they made the loan before they became insolvent.
No loan in 2012. And so it's a new loan that just came on the books. The ESOP looks like it just came on the books in 2013. As in 2012, there's, that note wasn't there. 28 of 48, Bart. It's the breakdown of the footnote on long-term debt.
Is this a new application?
No, this is a reapply, so it is treated as a new application.
They've been licensed before,
They let their license lapse,
and when they
so
were,
they have to,
okay, and when they were licensed before, how long were they licensed for?
their license number is 752, so a very long time.
Very long time. Okay.
I would say they
that-
would have been in the first 2 years of licensure, given their license number.
I'm okay for an exception because it appears that the assets being less than the liabilities is a function of the ESOP and the buyout.
And we have a history of them being licensed and not any problems, and so.
Yeah.
I make a motion we accept the financials provided.
Second.
Motion's been made and accepted that we accept this client, this company. All in favor say aye.
Aye.
Okay, thank you.
All right. We have one final application to review. And this application is on tab 7. I wanted to draw everyone's attention to the letter from the CPA that is on page 10 on your iPad. It actually does not have a page number itself.
What was our concern on this one, or
the-
your concern?
The concern here is the letter that is provided, because I don't know if the board would consider this a compilation report. This is not standard compilation
Language. yeah.
language. The information included from their accounting software, so.
But the letter covers it
Okay,
because CPA, professional tax planning and preparation, a full set of statements prepared by an outside CPA firm, they probably do the write-up for them and generate it out of a system as opposed to retype it. This is a very unorthodox cover letter, and there have been some rules changing recently in accounting where you can give a letter as opposed to a compilation. I'm not familiar with those rules. I haven't been to a course on it yet. And I don't know if this is that kind of letter. It may well be. You also on the accounting board? No, that was. This is QuickBooks.
and I'm presenting this just because it is outside
Yeah.
of the norm that we've discussed
All right.
between the
But
compiled,
did he give
reviewed
his
audit.
license number?
Yes, yes, and we do look them all up.
This guy is a licensed CPA.
Yes, he was licensed in 2005. His license is active through 12/31 of 15. He's licensed in the state of Minnesota.
This is a new license, right? Because I saw 6 months projected.
Yes.
So there's no trust account or anything because they're not collecting yet, I guess.
There appears to be a trust account, but it isn't a
$26,000,
requirement. They attest in the application that they do have a trust account. They're not collecting.
They're not collecting
They
here.
have $26,000.
Yeah, it says Bremer
Oh, I
Trust
see it now.
Account,
Okay.
$26,000.
Okay.
Yes, and looking back their application, the way they answered it, Bremer Bank is the trust account listed in the app.
So you've looked up Mark and he has a license.
Yes, sir.
He didn't put his license number on the letter, but that's,
Not put it in a letter per se, but I'm sure there's probably an email. We always request that they do send us that information. If it,
On
because
their-
many times it's not on the compilation letter.
Steve, on his
Their name
balance
would
sheet,
be-
they have other current liabilities of $27,000.
yeah.
Seems like a lot of other liabilities.
Well, they're
when
listed
this small.
above. 27,000 other current liabilities.
Other than that, because that doesn't
Yeah.
total up.
I'm sorry, what?
What we're looking at is total other current liabilities of $27,495. And I just want to be confident myself that other is not trust money. That's not money that they owe clients, because if they are, then they're out of trust. If that $27,495 is money that they owe clients, then their trust account is
It doesn't really say what it is on here.
doesn't show, their liabilities don't show any debt to, any fact that they would owe any money to their debtors, to their creditors.
They don't show it due to clients.
Well, it's saying exempt fiduciary. Line item is. Because the rest of it is the
Is
total payroll.
Yeah, I see. Exempt fiduciary. That sounds like trust. I mean, that sounds like due client.
But again, they wouldn't be collecting in the state of Tennessee yet.
Oh.
Yeah. That's okay, but this doesn't work in Tennessee. If you want to collect in Tennessee, this part.
Yeah,
I think that is what that looks like.
It's hard to say it's not because there's no other client liabilities that show up.
about a letter to them or a phone call or something explaining if they have money in trust, where does the debt owed to the client show on their financial statement?
I can certainly ask that question. Again, I will remind you, they're not collecting in Tennessee.
Right. But if they want a license here. And
Correct. I don't, but the trust, it says that they must maintain interest enough to remit to clients at all times. I can certainly ask the question. I'm not sure.
Well, the trust account shows 26,560 and this shows 27,270. So you're, and then of course there's 27,000 in the operating account. Now, here's what I find extremely interesting. As of April 15th, which means it's not a month end. So if they've done an interim statement, they may not have their trust account closed. They may still be passing it through. Or if this was a month-end statement, I would feel a lot stronger about what you're saying, Bart. But on an interim statement, as of April 15th, they just pull a financial.
Yeah.
You're in the middle of a month.
Yeah, they could have
That-
not moved
that's-
money from operating to
Yeah.
trust.
They could have gotten funds in, and because they got plenty of cash up there. So you may want to include a note. I'd say go ahead and approve it, but include a note saying in Tennessee, you must be in trust.
I think they're okay. I think we could approve
April
them.
15th is an unusual day to pull a financial.
But maybe just caution them that they have to, that subsequent financial statements have to show that they've maintained positive trust.
They do attest to that. That is an attestation question
Right. Okay.
on the application, that they have a trust account and sufficient funds are maintained in such trust accounts at all times to disperse such amounts due to all clients.
Not pointing out the contradiction, but the accountant pulled this at 8 o'clock at night on the 15th. That's one tired accountant.
You're working late. Well, it
Up in
was
the
tax
left-hand
day
corner.
too.
Yeah, it
I'm
was tax
surprised he
day.
did it at
Yeah.
all on April the 15th.
Yeah, that's why his letter's so short.
Okay, I make a motion that we approve with those caveats.
We should give them notice.
I'll have a conversation / letter with them. Send them a letter.
Second.
All in favor, say aye.
Aye.
Tab 8.
Actually, is the renewal update. Again, this is where you requested we track how many people are surrendering. Last meeting, there have been 20 additional surrenders. Sometimes these are a company with multiple locations and they're surrendering, closing, no longer collecting in Tennessee. I would say some of that has to do with the change in the law last session before last. So evaluating what they're collecting and whether a license in Tennessee is required. Again, we're still seeing that continuous flow of applications. On average, probably 6 or 7 a month. So.
Now we're ready for legislative
Yes.
update.
Tab 8 is your legislative update. I've included Public Chapter 291, and this is the public chapter that removes the budget requirement. And it's Section 9. Any other relevant information or documentation that may be requested by the board to determine whether the applicant meets the licensure as set in 6220-107.
What exactly is this doing?
It removes the budget requirement,
From the,
Six-month
from the
budget.
the
application?
6-month
Yeah.
budget from the application, and just puts in there the general term of any relevant information. So this is timely with our reviewing and drafting to change the initial application. So there will be a notify sent out, which I believe all of you are signed up for, that will let everyone who signed up to receive the notifications know about this change and any other changes that might affect, which would be UAPA, or they're still reviewing everything from the end of session to get everything passed. So.
Email question?
Yes, and I may defer to Ms. Baird on this question. The email, we've received this, the collection service email address, and it's related to definition. So if you'd like to take a moment and read through the.
So they're implying services are third party because they're not the holder of the note. Are they collecting it in the name of the servicer and the name of the holder of the note? They're collecting it in the name of the mortgager, and they're just servicing it. Then they're hired hand. But if they're collecting it in their own name because they bought it,
Might be that we need to have a follow-up question back to the questioner in order, because certainly we don't want to misstate thinking that we know what they're talking about when they may be speaking of something else. So if there's a follow-up question that we need to send back to the questioner to clarify in order for you to make a decision, we can do that. Just let me know what it is.
can of worms I've been worried about ever since we had that large case come through here that turned out to create this legislation that created this, is that banks buy debt from other banks. And I think that legislation kind of covered that with the personal guarantee and note exemption. So when a bank buys another bank's debt, are they now third party? Because they're not the first party on the debt. They're a purchaser. Now, we've never touched that area, and banks have been buying banks forever. So we've never touched that, to my knowledge, as a licensing requirement. And a servicer could have purchased the debt and is servicing it, for a discount off the face, because banks don't hold their mortgages anymore. They sell them off or pass them off to a servicer. Not first party because they're not the ones that originated the debt. I've been concerned about the whole area of collection requirements. Why aren't banks who buy another bank's debts licensed? Like that debt, because it's not their debt.
Originally their debt, but it's their debt now if they bought it.
So
So,
when
yeah. I
Bart and
know.
I used to buy debt, it's our debt now because we bought it.
right.
But my name was never on the note, and neither was Bart's, and neither is the bank's. It's other bank XYZ's on the note. Just like the mortgager, I don't know who actually holds the mortgage. A servicer that doesn't buy the debt, in this case, if they're just servicing the debt, they're actually not an employee of the originator, but they're an agent for the originator servicing it. Now, I don't do law, and I'm not talking about law stuff, but an employee is an agent, I believe. And they're an agent of the originator, then they're first party, in my mind. But if they bought the debt, then they've taken the place of the first party, and if they're collecting it themselves and haven't placed it with someone else to collect it, then they've purchased debt, they're collecting themselves, and that's third party. And I don't. I don't know the exemption for the notes because I haven't studied that on the new law so much. It was notes and personal guarantees that you don't have to be licensed to go after if they're purchased.
Doors box.
Yeah. I avoided even thinking about that out loud because now we have to send notices to all the banks that have ever purchased another bank and tell them they're unlicensed in Tennessee and they need to
Oh.
get their license.
Good luck with that.
Well, I think based on what this says, does not include any person that engages in or attempts to engage in the collection of notes or guarantees. What you do is buy a note from, whether it be a bank or an individual, and you attempt to collect it in the name of whatever, you don't have to have a license. Is that the way you read this part of it, Elizabeth?
Do you have a copy of that, the law?
I do. I have a copy of the chapter definitions section, and it's 622102. I'll just read the whole thing so you can get a general idea. It says collection service means any person that engages in or attempts to engage in the collection of delinquent accounts, bills, or other forms of indebtedness, irrespective of whether the person engaging in or attempting to engage in collection activity has received the indebtedness by assignment, or whether the indebtedness was purchased by the person engaging in or attempting to engage in the collection activity. Collection service does not include any person that engages in or attempts to engage in the collection of notes.
That just was about as on point as you can get, because servicer, yeah. And the definition of notes, look in Black's Law, that's the definition of notes for us. I mean, we don't have a definite, a note's a note, that's not that hard. Of course, if you got into, is it a verbal note or is it a written note, that could get ugly. Art, what do you think?
I think they don't have to have a license to collect notes.
No. That said, they don't have to have a license to collect
Does
notes.
not include.
Isn't that what it just said?
That's what
Right,
it
collection
says.
service does not include any person that engages in or attempts to engage in the collection of notes or guarantees.
Bought a bunch of sterling jewelry notes, and they had notes with their debtors. And you collected it yourself, you wouldn't have to have a collection license to collect notes. Or if you bought a bunch of of notes with personal guarantees, and you collected those personal guarantees, you wouldn't have to have a license.
Right.
That's what fairly plainly that says, doesn't it?
Yeah.
This guy's asking, are mortgages notes? Well, yeah. Mortgages, you don't sign the note. I mean, that's not hard. Ball game.
I think
I
that.
think I can, and if for some reason, further questions arise, I'll certainly bring it back, but I think this is a good starting point.
It eliminates the whole banking problem. When they passed that new law, I read that and I realized that they really threw a net over covering the banking issue of buying notes. Because prior to that, when a bank bought paper, it probably should have had a license, but now it really doesn't have to.
I doubt that was on the mind of the legislators when they passed this law.
Well, the legislators didn't write that.
Yeah, we
No,
never
the
know about
legislators didn't write that.
that. No,
No.
these guys from Rialto.
Those guys that came in and their council wrote that, and they were
Yeah.
sharp guys.
Are we okay now?
I think so, yes. I think we can work with this. No, I'm just gonna.
Ready for the application discussion?
Yes, would you like to take a break?
We could
Before-
now. Ms. Trinkler has to leave at noon.
Okay.
Or I have to leave about
Rest break.
20 till. I have to be somewhere.
Oh,
We
yeah,
have
me-
30
Take
minutes.
that long. I'll go really fast.
Yeah.
We have 30 minutes.
Okay.
Yeah.
Yeah.
Take just a short.
Yep. 5 minutes.
Sure.
finished with that.
Yeah, she's
We're on
going to run with it.
application now.
It's application. Discussion.
And we will have to conclude because we will, if when Ms. Trinkle has to leave, because we will do what we can today. We started this last time just reviewing the application, and I know all of you've had a little bit of time to look at it, and if there are suggestions, we can start to incorporate that. So maybe at the next meeting, we'll have a draft of what a new application could look like. So, is there anything?
I've made a few notes that
Okay.
we, maybe to start off. I think it's important, and when we lost our collection agency manager requirement, we kind of lost touch with our agencies a little bit. And I think that every year with the renewal, we should have we should know who the collection manager is, who is managing the collection floor at that location. I jotted down background check of the manager. Might be a good idea. A credit report of the manager, and this is just for discussion. And every year during their renewal, we'll want to know that information too. Because right now they make application and this is their CEO, and next year they may not have that same CEO, but we don't know who that is. It's important for us to know the lawyer's name and contact information that sues for the collection agency, that sues debtors for the collection agencies, and we need to know the lawyer that handles the corporate issues for that collection agency.
Why?
Well, for the lawyer's name?
Yeah. They may hire a variety of lawyers. I mean, it might change as soon as it comes in.
Well, this would be just on renewals. I think sometimes that we don't know who's responding to our complaint issues, and if it's the corporate lawyer that responds to our complaint issues, that we just need to know that that's who that lawyer is.
Well, shouldn't then we then ask for the designee of who will respond to any complaints? It may not be a lawyer. They may
that's
want
fine.
their accountant, or they may want somebody internally to do it. But who sues for them is different than the designee of responding to complaints.
There it is.
And I wouldn't want us to imply any requirement to use one firm over another, or that you have to stay with whoever you designate. That could be a backhanded implication. I mean, we're not trying to run their offices.
Well, no, I knew that. That's not the point is that if we have to communicate with a collection agency that may be operating in California, and we get a response from a collection manager or some underling from that agency about a complaint, we may want to contact that agency's attorney.
Well, I think I get the spirit of what both of you are saying, and I appreciate that, because many times when we're trying to get their bond updated or just trying to get in contact with them about a question, many times the only point of contact we have is their main call number. So we end up getting an agent. We say we're with the state of Tennessee. Then they kind of panic. We get a call center manager. Then we slowly work our way through the chain.
I'd like to have
so we don't
who's
get,
your designated responder to Tennessee, give us their cell phone, give us their phone, and if it changes in the future, you have to give us a new name. If this person leaves your company, you send us a new name on a continuing basis. So we need to point a designation. I would agree with that. Now, do we want to do a background check on the point of designation? I don't know. I mean, you said earlier, do a credit check on somebody. I don't know that we really.
So okay. So is the manager you're referring to also the point of contact, or are they two separate people?
I think you were talking about two separate things.
Be two separate people, likely. It may not be.
Well, there may
two
not be. I
separate.
think you can ask that question. You can say, is this the person that would be? And if it's yes, then okay, it can be. But if no, then who is the person?
Well,
When I was reviewing the application, I generally had and sometimes even in our meetings here, I feel like who do we get to talk to at an agency? And I know I'm trying to reach a company now that continues to solicit me for business, and I'm trying to find out who it is, and it's a collection agency actually a lawyer. But anyway, I'm trying to find out who to contact, and like you say, you call up and you get a debt collector on the phone. And then you get the supervisor, and then you get somebody else, and without knowing who to contact, we don't know who it is. And have the name and address and email address and telephone number of the person that we can talk to that can make some decisions. And in huge companies, it might be their lawyer.
Well, many times we're finding companies are establishing a compliance division, and they may have 2 or 3. Sometimes it is rolled up into their legal counsel's office. It varies. But I feel like what you're really looking for is who is responsible for their compliance, not only with the
Compliance/licensing, two different things.
well,
Licensing is a form of compliance, but compliance is more a CFPB issue than licensing. Licensing is kind of a thing we've always had. Compliance is new and evolving. I would say compliance licensing, or licensing and compliance.
Well, the way they use the word compliance, many times it incorporates their compliance with state licensing regulations and
Some do,
requirements.
some don't.
Yeah, but the people I've been speaking to more frequently have been with their compliance division. That's what they call it. So it seems to be just to find some terms that are industry that make it easy for them to complete it.
I would agree that we should request a point of contact with hard information and the requirement to, if that person leaves, to resubmit to us, that they're responsible for providing a contact person who can respond, email, phone, cell phone, how we can reach them. That's a good idea, but I don't know that we should ask for their attorney. I mean, that's who sues for them. That was a separate, you had those two separate issues.
2 separate attorneys.
Yeah, I mean,
And I'm not saying that we necessarily need them, just sometimes,
it's gonna be on the lawsuit.
yeah.
It comes to our attention. I mean, are we
I just
going
know
to
there's
begin
some-
to reach
I just know
out?
that there are some lawyers that, just because I know them and I see them on a lawsuit, I have an idea about what might be going on.
Oh, yeah. Oh, yeah. There's some that you don't want to see. I mean, but is that the level of
I don't
I'll
know
use
if
the
it's,
word
you know,
policing
I
that
don't,
way.
yeah, I don't know if it probably isn't.
Yeah. I mean, if we're going to start an outreach program to police or to govern our licensing at that level, but I think we've always been a responding agency as opposed to a advocacy agency.
Okay. Well, like I said, I just brought those 2 things up because I know that, I know that sometimes some lawyers doing work that I would rather them not be in this business.
But that's not under our purview.
No, okay.
But I sure do agree with your idea about having a point of contact and requiring that they provide it to us on a continuing basis. And to some extent, you could request their compliance officer or their licensing officer. I'd use the word officer, because most companies have a compliance officer now. Or their licensing officer.
Well, and I agree with the idea of who is managing the office or the collection floor, and I think that's the person you might want to ask for some idea of what their qualifications are, whether it's a background check or whether it's a resume or whether it's, something.
What we can do is basically we're just jotting down notes and taking things back, and we'll review it with legal counsel as far as, because that may trickle back over into, it looks like we're regulating the manager again, so we just have to work. So we'll take all of these things, Keeling and I will talk. We'll talk with the attorneys on up the chain, and everything will have to be reviewed. So you are
I
welcome to throw out.
respectfully disagree with my counterparts on requiring the name of the manager that governs the floor. Because if I wanted to do a credit check on anybody, it'd be the owner. Because that's
Well,
who's going to really.
I'm not so sure about doing even that. But if we have a complaint come in here and we want the notes on that particular debtor or wants to talk about those notes, rather than opening up a big, huge a file, maybe you could call and talk to the collection manager. The collection manager can go in and read the notes and say, well, this is what we've done, this is what was said.
If a collection manager read notes back to an attorney on the licensing board without going through the compliance officer, they should be pulverized. Not just shot and fired.
Yeah, you're
I mean, my gosh, if you
You're
had
right.
your collection
You're
manager
right.
Well,
give information out
Yeah.
without going through compliance or
Yeah.
licensing,
You're right.
and we have to, we
You'll
also
pull her
have
hair
to
out.
keep in mind what is reasonable for upkeep. Because if you're saying who the collection man or who's the advisor, if you have a 24/7, 365 business, you're going to have at least 3 of those to have 3 shifts. So you're going to have all of these different people and different times, and the rotating in and out. That's going to be a lot of upkeep. That
I
may
wouldn't suggest down to that level. It would
That-
be the
but-
person that supervises them. I mean, it wouldn't be,
But I'm just saying that still could be significant upkeep, and it may trickle back into it appearing like you're trying to
I'd only,
regulate manager. So just certainly take it back, certainly ask, just
I really do think it's a great idea to get a licensing or a compliance officer's name that we have direct line of communication to, that we can ask questions to. That would be a responsible party, and I'd use the word officer along with compliance or licensing, so it gives the connotation. We're not asking for the secretary in the department.
Those are the only things that I jotted down as far as what we need. There's some obvious things that we're going to change.
budget,
All
the budget
things I
requirement.
was going to change. I think that on the application, if it still says PA or CPA, we should remove the PA.
Well, unfortunately, that's in the law. It's still in the law. It's in our code. It still says PA, so. Are you saying they don't exist in Tennessee? Well, it doesn't say a Tennessee certified public accountant, so a PA could exist in another state.
Does our law say licensed PA?
License PA or CPA.
It says licensed. That's different, because if it just says PA and it doesn't say licensed, that guy who sent us, that Brickley guy who sent us that thing, could have finessed us by calling himself a PA even if he's not licensed.
Section 2 says a personal or corporate financial statement prepared by a licensed public accountant or certified public accountant.
I would say when they wrote it, they mirrored what Tennessee had. But it is not limited to Tennessee, so we would still include PA because the law says we can't
Statute
accept.
says, okay.
Are there any other specific questions? And again, too, if you'd like to send me something separately after the
Work in
meeting, if you have,
progress.
start thinking about it. This will be a, excuse me, will be a process.
okay,
So,
good.
so we
If
can,
you could report, if you could kind of come back to after you've talked with legal about some of the things. I think in the general conception that we have, we just need to know who to talk to at these agencies when something goes wrong.
I completely agree. We need it as much on the compliance side as we need it on the licensing side when we have a bond expire, when we have a question on a renewal. Many times their emails do not contain an address or a phone number.
It'd be nice
Eric.
if we put that in there, if you actually, when you all talk amongst yourselves, whenever we designate this, send a letter to all agencies requesting that information and notifying that it'll be, in the future, it'll be in their renewals, to go ahead and get it on file. Just get it now, because it could be a year and a half before you get it from somebody. And it'd be nice just to have a name and a phone number and an email and the notification.
Certainly.
I hope we don't have to go through the regulatory process to make that a regulatory item. But I'd feel strong enough that if we can't do it legally, that we ought to at least include it in our next regulations if we do them.
We'll definitely inquire, but we'll make note of the fact that that is a desire irregardless. So again, I know we're running short on time. If you're welcome to take this copy back. It's on our website. If there are additional items, please do not hesitate to email those to me. Remember, sunshine applies,
Okay.
so please just email me or Ms. Baird. Is there any other notes, questions, comments, concerns?
That does it on the application discussion. Nara?
NACARA, yes. The 22nd annual meeting is scheduled for September 28th through the 30th. It will be held in Denver. And if historically we've sent a board member and the attorney to the
I think last year just the attorney went.
yes,
Uh,
Chris
that's
was the only
that's
one.
just to approve the attorney. There have been years when the whole board went.
I've never been.
You weren't on the board. That was on Tom Edwards' days.
I've never been, I'm not, Denver's a nice town.
Well, I'd like to go. I enjoy it, and I get to hear what other states are doing. I'm not sure if Elizabeth or Chip or anyone else wants to go too, but
Well, I'm just bringing it because it is still very early because it's not until September. So if it's something you would prefer to defer until the next meeting when they are here, or I can inquire if either of them would like to attend.
I'm okay with not going, so I would vote
yeah.
for Bart to go.
Okay.
Second,
Okay. And Keeling may want to go too, and if we just get one approved, then Keeling, I'll bow to you if you want to go, and then I'll go if anyone else would want.
If that's the board's wish, I don't know about Mr. Hellman.
I guess, poll them to see if they want to go, and if they do, because I think we do have to get the request into budget here pretty soon.
Yeah, well, again, it still is quite early because it is not until September, so we do still have the July meeting get through, because we'll actually transition over to a new fiscal year before this takes place. I wanted to get the dates out there. They've recently published these, so I wanted to make everyone aware.
Any new business?
So,
Oh, sorry.
do we want to vote today, or do you want to put it off till?
Well, I think we need to, what,
you think Chip might want to go?
I don't know.
I'm fine if you want to vote for one, and we can always bring back a second.
Well, I'll make a motion that Bart attend.
Yeah, I'd second that motion.
All in favor, say aye.
Aye.
You recuse yourself.
You don't get to vote for yourself.
I got to go.
You can't vote on that.
That is all the business that I have.
Anybody else have any new business?
Motion to adjourn.
Stand adjourned.
Thank you.
Got you out of here.
Thank you.
You're welcome. Thank you. You won't be here in July, will you?
Well, I think I will now. I'm not leaving until later in the month. I'm not leaving until the